Welcome back to Silk Warrant. Today in this story is about a woman who was declared dead and spent 11 years quietly taking her life back.
She was sitting in my chair. My business partner, Renee Calloway, had redecorated my office and was running my company from the desk I'd built with my own hands, and she'd done it all legally. The room smelled like her perfume, jasmine and something synthetic, the same scent she'd worn to my funeral. I stood in the doorway and thought, she has no idea the dead woman filed paperwork this morning. On my wrist was a watch that had been in my estate sale. I'd bought it back for $40. Let me explain what it takes to disappear for 11 years. Not willingly, not at first. My name is Vivian Marsh. In the spring, 11 years ago, I was 34 years old, the co-founder of an interior architecture firm called Marsh & Calloway, and I was driving home from a client site in a rainstorm on a 2-lane highway in rural Georgia, when my car went off an embankment into a flooded river. They found the car, they found my bag, they found my jacket snagged on a branch half a mile downstream. They did not find me, because I had pulled myself out of that water, hypothermic and disoriented, and walked 2 miles to a farmhouse belonging to a woman named Ruth Ellen Grady, who put me in her spare room and called a county paramedic she trusted, not a hospital. By the time I was coherent enough to understand what had happened, it had been 4 days. By the time I tried to make a call, I learned that my firm's accounts, the ones requiring both signatures, had already been frozen pending my death investigation. And Renee Calloway had already retained an attorney. I want you to sit with that timeline. 4 days. She de-retained an attorney in 4 days. I had a hairline fracture in my wrist, a concussion that made screens impossible to look at, and a business partner who moved at a speed that told me everything I needed to know about how long she'd been planning this. Ruth Ellen was 73 years old and did not own a smartphone. She had a landline, a garden, and a deep, abiding suspicion of people who moved too fast. She'd grown up watching her family's land get absorbed by developers and banks and men who carried briefcases and spoke too smoothly. She recognized the shape of what I was describing within 20 minutes of hearing it. She said, "You don't want to go home yet, do you?" It wasn't a question. I looked at my wrist in the splint she'd fashioned from a wooden spoon and a dish towel. I thought about Renee's attorney filing paperwork in 4 days. I thought about the fact that Renee had always handled client relationships while I handled the design work, which meant she had every client's contact information, and I had every project file. Those files were on a server in my home office, not the firm's server. Mine. I said, "No, I don't." Ruth Ellen poured me more tea. "Here is what you need to understand about being declared legally dead. It doesn't happen immediately. It's a process, one that takes, in most states, either a court order or the passage of time. In Georgia, under specific circumstances with sufficient evidence of death, a petition can be filed after a reasonable period. Renee filed that petition in month 7. It was granted in month 14. By month 14, I had been living under my middle name, Claire, in a rented room in a town 2 hours from Atlanta, working remotely as a freelance design consultant under a business name that wasn't mine. Depositing checks into an account Ruth Ellen had helped me open with a money order and documentation I will not detail here. I was building something, not a life, not yet, a foundation, and I was watching. Because Renee Calloway had made one error in her speed, one slip in her certainty, and it was the same error that fast people always make when they're certain no one is watching. She de-kept the name, Marsh & Calloway, still running, still taking clients, still using the brand identity, the portfolio, the design language, all the work I had built over 9 years. With my name on the door of a firm, she was now operating as if she'd built it alone. My name on her door, that was her mistake, because my name was still legally mine. The watch appeared in an estate sale listing in month 16. I was doing what I did every few weeks, quietly monitoring what was being liquidated from my declared estate, which Renee had been appointed to administer as my named business partner and emergency contact. It was a silver bulova my mother had given me when I graduated. Engraved on the back, VM, you built this. Listed at $60, marked down to $40. I bought it from the listing, without hesitation. When it arrived in the mail, I sat at Ruth Ellen's kitchen table. I drove back to see her sometimes, on weekends, and I held it in both hands and made a decision I had been circling for 2 years. I was going to get it all back, not by announcing myself, not by walking into a courtroom and saying, "I'm alive, she stole from me." That was one path, and it was available, and I kept it available. But it was loud, and loud gives the other person time to move. I wanted the quiet path. I wanted to own everything before she knew I existed. The legal architecture of what I did next is something I want to describe carefully because it matters. An estate, once declared, has assets. Those assets can be sold, transferred, auctioned, liquidated. The estate administrator, in my case, Renee, had been selling off my personal property and transferring firm assets into her restructured company, which she had quietly reincorporated as Callaway Design Group, while keeping Marsh and Callaway as a client-facing trade name. What she had not done, what her attorney, apparently, had not flagged, was file a proper trademark assignment for the Marsh and Callaway name. It was still, technically, an unassigned asset of my estate. My attorney, a woman named Patricia Cole, whom I found through a legal aid network and paid in installments, described it to me this way. The name is still in the estate. The estate is still technically open pending final distribution, and if someone were to purchase that asset through proper estate channels before distribution closes, she let the sentence sit. I said, "How long do we have?" She pulled up the filing calendar. "The estate closes in 4 months. I had 4 months to buy my own name back from my own estate. This is the part people don't understand when I tell this story. I was not trying to punish Renee. I was not building toward a confrontation. I want to be precise about this because it changes what I did next entirely. I was trying to own the ground before anyone knew there was a battle. Over the next 14 weeks, Patricia and I worked through the estate's remaining unassigned assets, the trademark, 3 pieces of design software with transferable licenses that Renee had listed for liquidation, but not yet sold, a client contract template I had authored that had been filed with the firm's original IP documentation, and a hard drive, a backup drive that had been cataloged in the estate inventory, because when you're declared dead and your home is assessed, someone makes a list of everything in it. Renee's estate inventory listed it as external storage device, contents unknown, estimated value $0. She didn't know what was on it. She had listed it in the estate liquidation at no value, which meant it was available for distribution. Patricia filed the acquisition paperwork on a Tuesday. The drive was legally mine again by Thursday. It contained every project file from 9 years of Marsh and Callaway, every client contract, every design document, every proprietary process I had built, time-stamped, authored, unambiguously mine. Month 31, I had the name, I had the IP, I had the files. Patricia had been quietly preparing the legal declaration of my living status, a court petition to vacate the death declaration, restore my legal identity, and re-establish my civil rights. We had filed it in a jurisdiction that processed these cases carefully and without press attention. It was scheduled to be finalized in 6 weeks. That was when Renee made her second mistake. She pitched a new client, a large hospitality group, using a portfolio presentation that included, as its centerpiece, 3 projects I had designed and executed before my disappearance. Projects documented in those files. Projects with my name in the metadata. The hospitality group's legal team, doing standard due diligence, flagged a discrepancy in the IP chain. They asked Renee's attorney to confirm ownership of the design assets being presented. Her attorney sent a letter asserting that all intellectual property currently used by Callaway Design Group had been acquired through the estate of the late Vivian Marsh. Patricia received a copy of that letter because we had filed a prior interest claim on the IP. She called me at 9 in the morning and said, she just put her claim in writing. I was eating toast. I set it down. Good, I said. The hearing was a Tuesday in March. I wore a gray blazer and the Bulova watch on my left wrist. The courtroom was the kind of room that absorbs sound. Wood paneling, fluorescent light, the smell of old paper and climate-controlled air. Renee was already seated when I walked in. She didn't look up immediately. She was reviewing something with her attorney, her head bent, one hand resting flat on the table the way she always did when she was performing composure. Then her attorney's posture changed. Renee looked up. She looked at me for a long time without moving. Her hand on the table began to tap, index finger twice, then her thumb, a rhythm I had watched her do at client presentations whenever a question landed that she hadn't prepared for. Tap, tap, thumb. Tap, tap, thumb. She did it for approximately 8 seconds before she caught herself and flattened her palm. The judge called the session to order. Patricia stood and said, in the plainest language, "Your Honor, we are here to vacate the declaration of death for Vivian Claire Marsh, to restore her full legal identity and civil standing, and to address the matter of assets currently held under false pretense, including a trade name, a body of intellectual property, and client contracts executed under that IP, all of which Ms. Marsh has already legally reacquired through proper estate channels." Renee's attorney stood, sat back down, stood again. The judge looked at him. "Counselor," he said, "we were not aware that the subject was alive." The judge said, "Silence." I kept my hands folded. I did not look at Renee. I looked at the watch on my wrist. VM. "You built this. I won't give you the procedural details of what followed. What I will tell you is that the death declaration was vacated. My legal identity was fully restored. The IP claim was resolved in my favor, with documentation from Patricia that included the time-stamped files from the hard drive Renee had valued at $0. The Marsh and Callaway trade name returned to me. The hospitality contract, which Renee had been 2 weeks from signing, was renegotiated directly with my newly re-established firm. At one point during the proceedings, Renee's attorney made an argument that his client had acted in good faith based on available information. Patricia let him finish. Then she said, "Ms. Callaway retained an attorney on day 4 of her business partner's disappearance. The court may weigh that timeline as it chooses." Renee's hand was flat on the table. Tap, tap, thumb. I looked at her then, just once. I said not loudly, not for the room, just across the distance between us, "You were right that I was gone. You were wrong about whether I was coming back." I walked out of that courthouse into a cold March afternoon. The air smelled like rain coming, wet concrete, bare trees, the particular smell of a city before weather arrives. The same smell as that highway in Georgia 11 years ago. Different meaning now. I drove to Ruth Ellen's that evening. She made soup. We didn't talk about the hearing much. She asked if I was tired. I said yes. She said that was appropriate. She was right. I have been running Marsh and Callaway again for 2 years now. Not the same firm. I rebuilt it with different people, different processes, a different understanding of what I'm willing to trust and what I'm not. I don't move fast. I don't assume the ground beneath me is stable just because I can't feel it shifting. I am quieter than I was before, more deliberate, harder to surprise. The watch is on my wrist every day, not as a reminder of what I lost, but as a record of what I proved. That the things built with real labor have a way of finding their way back to the hands that made them. Here is what I want to leave you with. There are people in your life who have already written your ending. They have a version of you that is fixed, finished, past tense. They have made decisions based on the assumption that you will stay exactly as small as they need you to be. The most clarifying question you can ask yourself is whether they're right. It's whether you've ever actually shown them what you're capable of, or whether you've only ever let them see what they were willing to look at.